continue for international worker. But in case somebody, in case when we got the, if we will get the decision from the Supreme Court in future, then we need to change it. So these were some nitty-gritty of the Provident Fund, and things were there. Now I will take one very important topic, CTC structure in alignment with the PF Wage Code 2019. Dear friends, Code on Wages 2019 is around the corner. Anytime, I think most of the states have already been come up with their state rules. So the Code on Wages 2019, along with the other 3 codes, they are going to be implemented very soon. In such scenario, I will say, please keep your working ready. And in case, if in your company, in your organization, in your factory, if you're as a practice, if it's not your basic is less than 50% of your total remunerations, means CTC, then you need to restructure your salary. Because once this Code of Wages 2019 gets implemented, what will happen? You cannot keep basic less than 50% of the total CTC. If you keep less than 50% of total CTC, your basic salary, it means what will happen? You will get non-compliant. Now, I am talking about the CTC. Or let me tell you, CTC or gross, the CTC has never been defined in the any labor laws. So CTC is a corporate term. If we talk about, legally in labor laws, it's a legal word. The CTC is not a legal word. However, it has been defined by the authority, PF authority, some time back. The CTC can be anything. But if we talk about the legal words with the, legally, if we define, we can say this is a gross or total emoluments or total remunerations. So in simple word, if somebody is being hired for 1 lakh rupees per month as a gross, as a CTC, as a total remuneration, as a package, or we can say this is a fixed CTC, then you don't need to keep basic salary below 50,000. If you have committed someone through your legal contract to pay a fixed CTC of 50,000, 1 lakh rupees per month, then your basic should be minimum 50,000. If you keep basic 30%, 40%, then you would become a non-compliant. Or for the organization who are currently in a phase of having a practice of 30% or 35% or 40% of the basic, what they will have to do? They need to restructure their salary, and resulting what will happen? There the leave encashment and the gratuity provision as a whole of the company will increase. In simple language, suppose in your company, if your company keep a basic 30% of the total CTC, it means 30%. When this code on wages will get implemented, what will happen? You need to increase the CT, you need to increase the basic up to 50%. Once you increase the basic, the other components which are depend on the basic, like gratuity will be increased in the same proportion. This would be the financial exposure to your organization. Employer PF, this will also increase because PF is depend on the basic. Gratuity is depend on the basic. Leave encashment is depend on the basic. So for the organization who are in a practice of keeping the very lower basic, they will be in trouble. For those organizations, I ask you, please prepare the self-assessment, you prepare the impact analysis with the financial and legal exposure and share with the management in the presentation. Then you will get to know how much extra burden is going to be, on the employer. Now let me tell you one more very important point when we are discussing on the gratuity. This is also very debatable, and from last, I think, last 30, 40 years, even in last 10, 20 years, I have seen there is a much debate on 240 days, 4 years and 240 days in gratuity. People keep asking, मुझसे भी बहुत सारे लोग पूछते हैं कि what does it mean, somebody who has completed 4 years 242 days, shall I need to pay the gratuity? So let me tell you very clear. There is one judgment of Madras High Court where it was upheld कि person who has completed 4 years and 240 days, it would be assumed as a continuous complete year after 4 years. Means 4 years and 240 days. If somebody who is completing, then he will become, it is assumed and it is deemed he has completed 5 years. And you should legally, you should pay the gratuity accordingly. There are various other case laws also, but this is a very important case laws of Madras High Court. You can refer. Now come to the what lots of person keep debating on 240 days, where it is written, where it is written. So it is already in your law. It is already in Gratuity Act 1972. You can see. It is very much there. It is written if somebody who has completed 240 days, and that includes accidentally leave and other things like layoff and strike, which is not being from the default at the default of the employee. So these all things are included. Even maternity is included in your 240 days. So agar somebody who has completed 240 days, and which is also including the accidental maternity leaves and other leaves, then still he is liable to pay the gratuity. So it is very clear. Law is very clear. If somebody who is completing 4 years to 40 days, they are eligible to get the gratuity under Act. Now come to the last point. I'll discuss the prevention of sexual harassment. POSH is very important. Nowadays, the act was enacted in 2013, and now we are in 2024. And there was some time to time there were some amendments, and now we are at the position we can say we have a very stringent act to protect the modesty of the woman. And there are few things that I would like to tell you. Before 2013, there were some issues, like there was no defined sexual harassment definition was there in the Indian Penal Code or other acts or other law, any other law. The definition was not defined. There was no IC, there was no internal committee. So what happened, the rest, most of the complaints gets unreported. तो reports ही नहीं होते थे sexual harassments के cases. Since this POSH has come into the existence in 2013, and various other compliance has come into the, like awareness, sensitizing session, capacity building program for IC members. So these are the very, very important development and growth in terms of to protect the modesty of women while workplace. So dear friends, let me tell you some very, very important nitty-gritty for all of you, because I know you all are aware about the IC, what are the role of IC, what does it mean by the POSH, how to conduct the sensitizing session, what frames sexual harassment, what does not frame sexual harassment, what does it mean by the welcome or unwelcome act. So these all things I think you all are aware. I will tell you some other things. First thing is whether you have filed your annual return. Annual return is very important, because there is a penal provision up to 50,000 or double the 50,000, means 1 lakh, or including to the to suspend your license, business license. So the penal provision is very grievous in POSH. So please make sure you need to file one annual return, and its last date is always 31st January. So for this year, you need to file your annual return by 31st January 2025. One more thing, have you displayed the abstract of POSH in your organization? Have you displayed the consequences and penal provisions being defined under POSH in your organization? No. Have you displayed the IC, list of IC member with contact number in your organization? So if you have not displayed, this is also a non-compliance. One more thing. You have the IC members, but tenure is, what is the tenure of IC member in your in POSH? Anyone can write in the chat box. What is the time period or what is the tenure of any IC member? Because this tenure gets expired. It is for a limited period. No, it's not 5. It's 3. Yes. You need to check in your organization what will happen. Let me tell you. Sometimes what happen ki aapko, you don't know, even you forgot my IC has been expired. When your IC member's tenure has been expired, means the jurisdiction is automatically expired. They will not take any, they cannot conclude any proceedings. If your expired IC members has taken a proceedings and pronounced the recommendation, what will happen? The respondent may go to the appeal and he will say their IC members has already been expired because the tenure is only 3 years and they are there for last 5 years. What will happen? So you need to check where your IC members, their tenure, when you have given them the appointment letter, their contract letter. There must be one contract. When you appoint the IC, when you deputed the IC member for the IC, you must have some, right. You should give one letter to all the IC members, including the external member. There should be one contract. And when that contract would be for the only 3 years. And once the contract gets expired, you need to renew, you need to recruit new IC members. Now, one more thing. What happened, generally I have faced. Can you please explain on POSH LCC? This is the POSH LCC. This is called local committee. So basically, there are 2 types of committee. One is an internal committee for the, basically, what does it mean, the IC? Let me tell you. It is mandatory for the all private organization as well as government organization where 10 or more employees are there. The organization where they don't attain the threshold limit of 10 employees, they will be governed by the district officers, and district officer under his presiding, they prepare one local complaint committee. So both the things are different. When you have 10 or more employees in your organization, you need to form one internal committee. In case you don't have the 10 employees in your organization, irrespective of male or female, then your organization will be, any case, if comes to your organization, suppose there are only 7 employees, including male or female, or then your proceeding will be taken care by the LCC, which is headed by the district officer. So each district has their own LCC. This is called local complaint committee. This is a government committee. So these are some nitty-gritties of the POSH as well. Now I will take your cases, your queries. So the first one, the query was, if we are paying allowance to some particular category, 30%, and not to all employees, then is this allowance to be considered for PF? Who asked this question? Mr. Ramya. Okay, sure. So this is very good question. And my answer is a very straightforward. Like I have explained, we have a thumb rule of UNO. If we have paid any allowance universally, ordinarily, necessarily across the board, then it will come under the PF basis. But we are paying some allowances to a particular category, 30% people, only to the 30%. It means this is a region based. There is a reasoning behind. There must be policy. There must be one MOM. How you identify these 30%. So this is called the reasoning. This is called region based allowance. So you don't need to deduct PF on this allowance. Now, let me take it ahead, one step ahead. Sometimes what I have seen, the special allowance in CTC structure, when I asked, it means this is not my comment. The Honorable Supreme Court commented, yeah, I have seen one allowance. This is called special allowance in the CTC structure in case of Vivekanand Vidya Mandir. So Supreme Court judge asked, I think this is a special allowance, so this must be given to some special employee. A special employee means he must be performing some special performance, some special function, some special operations. But it was not so. When the council of the Vivekanand school, when he started arguing, there was no defense because its name was special, but actually it was not special. It was given across the board. So this is the, basically this is the reasoning. So this is the thumb rule. What I am saying, any allowances, if you are paying across the board, it will come under the PF purview. But if you are not paying to all, it will not come to you. Now, let me tell you one more very good example. There are company A and company B. Company A is paying 2,000 rupees to its 40% workers. Only 40% workers. 2,000 rupees. And company B, it is paying 2,000 rupees conveyance across the board to all the workers. So there is a difference. Company A is paying to only those workers who are coming from far and who actually incurred the expenses in local conveyance while train or bus, whatever. But on the basis of the company A identified a list of workers and they are paying to compensate their local reimbursement, local conveyance on daily basis while commuting to the office to discharge their jobs. So they are paying. But company B is doing something else. What they are saying? They have not done anything. They are just giving 2,000 rupees to across the board to all the companies, to all the workers, and they are not deducting PF. They are also not deducting their PF. Who will be penalized? This is question to you. Company A or company B? Who is non-compliant? You just chat, you just answer in your chat. Who would be penalized? Company A or company B? Any answer? Yes. Company A is correct. They have a region-based allowance. They are giving the conveyance to only those who are legitimate, legally entitled for the conveyance because they are actually they have the expense. They are actually incurred the expenses while commuting to the factory. But company B is not doing anything. They don't know whether the person who is residing where, kaun kahan rehta hai, they are just giving the 2,000 rupees and not deducting the fees. Company B would be penalized. So this is the UNO. This is the complete analysis of UNO. Now the second question was related to may I know the legal words according, may I know the legal words according first point from your side. In the appointment, what point we need to mention for legal case as safe side, as you told, please provide. So I will tell you, like I have explained, you must have some very mandatory clauses in your appointment letters, like your jurisdiction should be there. In case of any dispute, the jurisdiction would be Bombay because my company is in Bombay. My registered office is in Bombay. If you come, suppose your employee goes to the Delhi and he lodges a civil suit in the Delhi, so you will have to travel from Mumbai to Delhi. That's why I am telling you, your appointment letter should have the jurisdiction. Your appointment letter should have the clause of arbitration. Your appointment letter should have the clause of clearly defined the conditions of termination, clearly defines the clearly defines the notice period. One more thing, very important, abhi yaad aa gaya mujhe. In case somebody who has an annual bonus in his CTC structure, in his package, and he resigned in month of October, and there is nothing but nothing was mentioned in case your annual bonus, which is a part of your annual CTC, in case you resign in during the year, what would be the remedy? Would you means either you can be paid on prorated basis, or you will not be entitled for annual bonus because you have resigned, but it is not mentioned in your appointment letter. Then he will go to the court and he will ask you, till the time I have been there, you need to prorate accordingly, you need to pay the annual bonus. So it should be written clearly. In case you resign in mid of the year, you would not be entitled for annual bonus, which would be provided and paid to you after the, at the end of the financial year. And it is always subject to the performance of individual and as well as the organization, and it is the sole discretion of the employer. It should be written. Conditions of the termination, in what condition you would be terminated, it should be written. You must have non-compete clause if in case like if your company is in practice of, it's depend how the culture and what is the the structure of your company. All the negative covenants, it must be there, like like non-compete, non-solicitation, non-poaching. Employment bond, it is the call of the organization whether you want to keep the employment bond for 1 year, 2 year, in case you are providing the training. And you can call me, I will give you my credential here in case you want to discuss or want a legal advice on legal bond or employment bond for 1 year, 2 year, what can be a rational, what can be a repercussion, I will advise you. And one more thing, you please prepare your code of conduct policy with disciplinary proceedings. Everything should be clear. So while you face any dispute, you can say, please go to the record. This is my policy. You just see my policy. You just refer your appointment letter, clause number 3, clause number 2. But agar kuch hai hi nahi, to fir you will not say anything. What happened? You will get the adverse judgment from the authority immediately. Even a 1 or 2nd hearing में ही आपके खिलाफ adverse judgment आ जाएगा management के खिलाफ, and you will have to reinstate. Now come to the third question was, if we consider CTC to be the contribution of the employer like PF, NPS, gratuity, labor. Yes, very much. Like already clarified, CTC is not a legal word. CTC is a corporate word, cost to company. You can have n number of things in your cost to company. Whatever the employer incurred the expenses on the employee, like car, driver, accommodations, even kuch bhi. If somebody, suppose I am having one cabin and the AC is running and it costs to the employer, they can put the same in my CTC. Gym reimbursement, gym membership, club membership, health insurance, they all can be a part of CTC. CTC is not never defined in the labor laws. This is a corporate term. So CTC can have everything. For legal word, for labor laws, the matter is, क्या matter करता है? Only gross salary, basic salary. Any more questions? I would. There is one question from Ankita Raj. I would like to understand on PT, why do we pay 300 in month of February? However, we pay 200 for rest of the month. What is the logic behind? Very important and very good. Very nice question, Ankita. Thank you for asking this question. This is generally, ये होता है basically. Let me tell you, professional tax, this is a state tax act. And as per act, across the country, Any state, Telangana, Maharashtra, whatever, wherever the professional tax is applicable. However, professional tax is not applicable in North India, but except North India, it is everywhere is applicable. An individual, an employee can pay 2,500 rupees in a financial year, not more than that. So that's why what happened, there are 12 months in a year. So 12 month into 200, it goes to 2,400. In month of February, they take additional 100. So it goes to 2,500 per year. This is your answer. Or in case if you have any query, I will feel honor to address. Thank you so much. So this workshop that I have planned for 1 hour, 11 to 12 hours. So I have completed this 1 hour training, or we can say workshop or discussion. Anyone, if any one of you, if you want to say something, you want to discuss something, or you please raise your hand. I will address, I will allow you to ask, and let me see. So over to Amar. Thank you, dear friends. Thank you for being patient and for interactive session. I really appreciate the way you engaged, and thank you once again. I am sharing my login credential in case you want to connect.
Hi, sir.
Yes, you can ask.
Hi, sir.
Yes, yes, yes.
Thank you for this fruitful sessions. Sir, I have one query. Suppose करो हमारा कोई last employee था वो जो अपना PF था वो उनकी एक्चुअल बेसिस पे काट कर चला गया। सपोज लगा तो उसको कुछ प्रॉब्लम्स होगी
Your voice is
उसमें, या ये एक तरीके से नॉन कंप्लायंस हो जाएगा?
I was not properly listened to you because your voice was distracting. What
सर मैं बोल रहा हूँ अभी आ रही है सर आवाज क्लियर आ रही है?
हाँ पूछिए।
मैं बोल रहा हूँ जैसे हमारा कोई लास्ट एम्प्लॉय है, लास्ट HR था जो हमारी एम्प्लॉय का वो एक्चुअल बेसिक पे PF काट दिया उन्होंने। सपोज करो अगर 50,000 उनकी बेसिक है तो उसी पे उन्होंने PF काट दिया। इन फ्यूचर एम्प्लॉय को जब विड्रॉल करवाएगा तो उसमें कोई प्रॉब्लम आएगी या
No, nothing, because he has paid 12% of the basic. This is the law, no issue. However, what I have said, you are obligatory mandatorily to deduct PF up to 15,000. If you deduct up to 15,000, 12% means 12% of 15,000, it goes to 1,800. This is mandatory. Over and above, it's not mandatory. It's voluntarily. If your basic is 50,000, you are flat deducted 12% of 50,000 and you deposit it. There is no offense. There is no problem. So, dear friends, we will upload our this session today. So, and I'll share the link here. How you will, Amar, share the link? How they will let you? How they will get to know?
I will share the YouTube link of this chat box.
Hmm.
There are a few more questions. Ankita Raj is asking, can you help me understand the OT rules?
Ankita Raj, OT rules, you can share me or what you want to, what's your query, what's your doubts on overtimes. Uh, I will, I will address, I will explain all the nitty gritties of overtimes and how to become a compliant, how to be compliant under OT. Thank you, dear friends. Once again, it was a very lovely session having you, such distinguished group of professionals, and this was a nice query, nice interaction. Thank you so much. Now over to Amar. Amar will say something.
Thank you, everyone. So we have already shared the YouTube link where you can access, you can subscribe this channel where we upload today's session as well. And continuously, we are trying to upload more details about the labor and HR professional details, compliances. And definitely, if you have any issue, you can reach out to us. The credentials we already share. Grijesh.gupta@bluelotusstrategy.com. This is the mail ID where you can write your concerns. You can share with us. Thank you for stay connected with us. We are closing this session right now. Thank you, everyone.